This is a special DGH News and Information report on the recent Supreme Court ruling on federal employment and its impact on the U.S. civil service, particularly the U.S. Virgin Islands. The DGH News and Information Network team of specialized agents researches topics that are of wide appeal to our listeners when we feel it is important to highlight things in the news that may go unnoticed but may have significant and widespread impact on the general public. Welcome, esteemed listeners. Today, we're taking a deep dive into a topic that has sent ripples and, well, for some, seismic shocks through the very foundations of American governance, the recent Supreme Court decision on federal employment.
It's a huge topic, definitely one that deserves a closer look.
Absolutely. Our mission today is to really unpack the profound implications of this ruling. It fundamentally alters the landscape of federal employment, granting the president expansive new authority over the careers of tens of thousands of civil servants.
Tens of thousands, potentially more.
Exactly. We'll explore the historical context that led us here, the legal shift this ruling represents, the wide-ranging national consequences, and then we'll zoom in on a region uniquely vulnerable to these changes, the U.S. Virgin Islands.
A really critical case study for understanding the real-world impact.
It really is. We've compiled an exhaustive analysis from critical sources like erosion of civil service, a USVI case study, and federal layoffs, civil service and Virgin Islands impact, along with, in-depth reports from Reuters, Politico, federalnewsnetwork.com, and, well, many others.
A lot of material to sift through.
A lot. Our goal is to distill the most important nuggets of knowledge from these materials, ensuring you're not just informed, but truly well-versed in this critical development. So let's begin this journey to understand what this ruling really means for the fabric of our government. Okay, so to truly grasp the gravity of this recent Supreme Court ruling, we first need to understand what's being disrupted. The American civil service, as we know it today, wasn't always a system based on merit.
No, not at all. Its origins are rooted in something far less ideal, actually.
Right.
That's really an essential starting point. The very idea of a professional, nonpartisan civil service built on expertise and competence. That's a relatively modern invention in American history. It really emerged from a deliberate, painstaking reform movement spanning over a century.
A long time coming.
A very long time. And it was specifically designed to combat the pervasive corruption that defined federal employment back in the 19th century. Before this reform, the prevailing system was, well, notoriously known as the spoils system.
The spoils system, right. Give us a sense of what that actually looked like.
Well, imagine government jobs, everything from postmasters to customs collectors being handed out not based on qualifications, not at all, but as rewards for political loyalty and campaign contributions.
So basically, patronage?
Exactly. It led to rampant cronyism, widespread inefficiency, and just this constant turnover of staff with every single change of administration. It was, as you can imagine, a system where who you knew mattered infinitely more than what you knew. And public service, well, it often suffered greatly because of it.
And there was a specific event that really pushed things towards reform, wasn't there?
Yes, the tipping point, or maybe the tragic catalyst, came in 1881, the assassination of President James A. Garfield.
Yeah.
He was killed by a disgruntled office seeker, someone who felt he was owed a government job.
Just shocking.
Absolutely shocking. And it starkly highlighted the desperate need for fundamental change. So just 2 years later, in 1883, Congress responded. They enacted the Pendleton Civil Service Reform Act.
The Pendleton Act, that's the big one.
That's the cornerstone. It was a revolutionary piece of legislation for its time. It established the groundbreaking principle that government positions should be awarded based on merit, primarily through competitive examinations. It also created the Civil Service Commission to oversee this new merit-based process.
And
crucially, it made it unlawful to fire or demote federal employees for purely political reasons. This was a monumental leap away from that patronage system, the spoils system, that had largely dominated federal employment since the era of Andrew Jackson.
So that sets the foundation. But the system continued to evolve, right? There was another major reform much later.
That's right. Fast forward nearly a century, and you get the Civil Service Reform Act of 1978. This commitment to merit was further solidified and modernized. It was a landmark piece of legislation that reaffirmed the nation's dedication to a truly merit-based system.
And it set up the modern structure we're more familiar with.
Exactly. It reshaped the modern structure for managing the federal workforce and created key institutions that remain central to its operation today. For instance, the Office of Personnel Management, OPM, was established. That's the federal government's HR agency, handling everything from hiring to retirement. Then there's the Federal Labor Relations Authority, or FLRA. That was put in place to oversee labor management relations, essentially acting as the referee for federal unions and agencies.
Got it.
And perhaps most critically, the Merit Systems Protection Board, the MSPB. That was created as an independent quasi-judicial agency. Its job: to adjudicate employee appeals when they believe they've been unfairly treated or disciplined.
So the MSPB is like the court system for federal employees facing discipline.
In a way, yes. A neutral arbiter. The explicit purpose of this entire legal framework, Pendleton, the 1978 Act, all of it was to protect the ability of civil servants to exercise independent, expert judgment, free from the fear of political retribution.
So they could serve the public interest, not just the current administration.
Precisely. The idea was to ensure that the government truly serves the public interest as a whole, rather than the narrow, shifting personal or political agenda of any particular administration.
So when we talk about protecting civil servants, it wasn't just a general sentiment, like you said. This system was designed with very concrete, legally mandated safeguards. What were those specific pillars of protection built into the system? How did it actually shield career federal employees?
That's right. The merit system isn't just an abstract idea. It's a robust legal structure. It's fortified by both statutory laws and, importantly, constitutional protections. These safeguards are what provide job security and offer avenues for recourse against unfair treatment.
And that's what makes it different from, say, most private sector jobs.
Absolutely. It fundamentally distinguishes federal employment from the more common at-will doctrine prevalent in the private sector. At the heart of these protections is the right to due process.
Due process, okay.
For career federal employees, those who've completed their probationary period, the Fifth Amendment to the Constitution, along with this whole web of civil service laws, guarantees they cannot be subjected to adverse actions.
Adverse actions being things like firing, suspension.
Exactly. Removal, suspension, demotion, those kinds of things. They can't face those without just cause and fair process. And this isn't a mere formality. It involves specific, legally mandated steps.
What kind of steps are we talking about?
Well, for instance, if an agency intends to take an adverse action, it must provide the employee with at least 30 days advance written notice, and that notice has to clearly detail the specific reasons for the proposed action.
So they know exactly what they're being accused of.
Precisely. Then the employee must be given a reasonable amount of time to respond, both orally and in writing. And they have the fundamental right to be represented by an attorney throughout this entire process.
An attorney, okay.
And finally, they have to receive a final written decision. So it's not just a quick, "you're fired." It's a series of legally defined steps to ensure transparency and fairness. It's about making sure any disciplinary action or firing isn't arbitrary, but is actually fair and justified.
And if the agency goes ahead anyway, what then? What's the recourse?
Well, should an agency proceed with an adverse action, the employee possesses a powerful right of appeal to the Merit Systems Protection Board, the MSPB, which we mentioned earlier.
The independent board.
Exactly. This independent quasi-judicial agency serves as a neutral arbiter in these disputes between federal agencies and their employees. The MSPB holds the authority to conduct full hearings, review evidence presented by both sides.
So, like a trial, almost.
Very similar. And crucially, it can overturn an agency's decision if it finds that the termination was unjust or improper. This means the MSPB can order the employee's reinstatement, often with full back pay.
Full back pay? That's significant.
It is. This right of appeal is really foundational to the entire system because it is specifically designed to prevent arbitrary, unfair, or politically motivated firings. It ensures that competence and conduct, not political allegiance, determine a federal employee's fate.
So due process, the right to appeal to the MSPB. What else?
Well, beyond those, federal employees are also shielded by a broad array of anti-discrimination and anti-retaliation laws. For example, Title VII of the Civil Rights Act of 1964 protects employees from discrimination based on factors like race, color, religion, sex, national origin, age, disability, and so on.
And they have a way to report that.
Yes, if employees believe they've been discriminated against, they can file a complaint with their agency's Equal Employment Opportunity, or EEO, office. Furthermore, federal law provides robust protections for whistleblowers.
Whistleblowers, right. People who report wrongdoing.
Exactly. Those brave employees who report waste, fraud, abuse, or dangers to public health and safety. There's actually an independent agency, the Office of Special Counsel, OSC, specifically tasked with investigating and prosecuting prohibited personnel practices.
Which includes retaliation against whistleblowers.
Explicitly. Retaliation, nepotism, coercing political activity. All prohibited. What this all means is that these aren't just bureaucratic hurdles. They are essential safeguards for a professional, apolitical workforce, ensuring that critical government functions are carried out based on facts and law, not political whims.
It's clear how comprehensive and deliberate these protections were designed to be. A system really built to shield experts from political pressures, allowing them to do their jobs without constantly looking over their shoulder. But as we know, this meticulously built system has been under constant pressure. Which brings us to the inherent tension at play here, the conflict between the president's, expansive Article 2 executive authority and Congress's power to structure the government and create these protections.
Precisely. That tension is truly at the core of this entire discussion. The painstaking, century-long effort by Congress to build this professional, merit-based civil service has always coexisted in a state of, constitutional tension with the formidable powers vested in the president by Article 2 of the Constitution.
Article 2. The executive power shall be vested in a president.
That's the one. Proponents of expanding presidential authority over the federal workforce base their arguments on a maximalist interpretation of this clause. They claim the president holds sole and exclusive authority over the executive branch, including the unfettered power to manage, discipline, and remove federal employees to ensure the faithful execution of federal law.
So the idea is the president needs total control to run the executive branch effectively.
That's the argument. From this perspective, the vast administrative state comprising millions of federal employees is merely an extension of the president's authority. These officials, they argue, derive their power from the president and therefore must be directly accountable to him. After all, the president and vice president are the only members of the executive branch elected by and accountable to the American people.
Okay, I see the logic there.
So in this view, the very civil service protections enacted by Congress, like requiring just cause for termination or allowing appeals to the MSPD, are seen as an unconstitutional infringement on the president's core executive function. These protections, they contend, create an unaccountable deep state of career bureaucrats who can resist, undermine, or even sabotage the policy agenda of a duly elected administration.
Deep state. That's a term we hear a lot.
It's a powerful, politically charged narrative, certainly often heard in modern discourse.
And this argument has driven efforts to weaken those protections.
Consistently. This constitutional argument has fueled political and administrative efforts to weaken civil service protections and introduce widespread at-will employment for federal workers. For years, legislative proposals aimed at achieving this goal have been introduced in Congress.
But they usually failed.
They've largely been defeated, yes, primarily because bipartisan support for the merit system has historically held firm. There's been a recognition across the aisle of its importance for stable governance.
So, unable to get it through Congress, they look for another way.
Exactly. Faced with these legislative roadblocks, executive branch strategists sought a different, more direct path. This is where the concept of Schedule F originally emerged. It was devised specifically as a way to leverage the president's existing executive authority to bypass the need for congressional approval and achieve that long-sought goal of greater control over the bureaucracy.
Schedule F, how did that work?
The core idea was to reinterpret existing statutory language, specifically that exception for policymaking roles we'll discuss later, to create a new category of accepted service employees. These employees would effectively be stripped of their long-standing merit system protections.
Finding a loophole, essentially.
You could put it that way. And this brings us squarely to the judiciary's pivotal role. The fundamental conflict between a president seeking to assert broad Article 2 power and a Congress seeking to maintain a stable statutory merit system created a profound constitutional question.
A question only the courts could really settle.
Exactly. Only the Supreme Court could definitively settle this long-running political and ideological battle. We've seen previous administrations issue and rescind executive orders attempting to create or block a Schedule F-like system. For example, just recently, April 2024, the Biden administration finalized a rule explicitly designed to strengthen civil service protections.
Trying to head this off.
Precisely. Clarifying that career employees couldn't be stripped of these safeguards if their jobs were merely moved to a different service schedule. So a Supreme Court ruling validating the president's authority to unilaterally create a new class of at-will employees wouldn't be an isolated event. Instead, it would represent the decisive judicial resolution of a long-standing, deeply consequential debate over the very nature of executive power and the future of the American civil service itself.
Okay, now let's fast forward to July 2025, and the ruling that truly sparked this deep dive. The Supreme Court has, in effect, released what Justice Ketanji Brown Jackson evocatively called the president's wrecking ball. This decision, coming from what's known as the shadow docket, marks a profound paradigm shift.
It absolutely does. A paradigm shift is exactly the right term. On July 8, 2025, the U.S. Supreme Court issued an unsigned order. It was an 8-1 decision, with Justice Ketanji Brown Jackson dissenting. And this was nothing short of a seismic shift in American administrative and constitutional law, precisely because, as you said, it came from the shadow docket.
Explain the shadow docket for listeners who might not be familiar.
Sure. It basically refers to decisions the court makes quickly, often without the full briefing, oral arguments, or lengthy signed opinions we see in their major cases. But the shadow docket rulings can still have immense immediate consequences.
And this one certainly did.
Absolutely. The key action here was that the court lifted lower court injunctions that had previously blocked President Trump's February 2025 executive order. That order had directed agencies to prepare for large-scale reductions in force, essentially setting the stage for significant personnel changes.
So the court cleared the way for those layoffs.
It did more than that. What the court's majority signaled quite explicitly in the order was that the president was likely to succeed in arguing that such broad layoffs are squarely within his executive authority. That signal was crucial.
Okay, so what was the legal basis for that signal? How did they justify it?
It comes down to a radical reinterpretation of a specific statute, 5 U.S.C. Section 7511. This statute, historically, is what defines which federal employees are entitled to full due process protections, basically, the blueprint for who gets job security in the federal government. Now, while it generally provides broad coverage, it contains a crucial exception. It exempts positions of a confidential, policy-determining, policy-making, or policy-advocating character.
Ah, that phrase again.
Exactly. For decades, this exception was interpreted very narrowly. It typically applied only to a small group of non-career political appointees and maybe their direct confidential assistants.
High-level political jobs.
Right. But this ruling dramatically expanded the definition of this phrase. It effectively grants the executive branch incredibly broad, unprecedented discretion to decide which career positions now fit this vastly enlarged description.
So career professionals could now be labeled policymaking even if they weren't before.
Precisely. And in doing so, the court validated the president's assertion of inherent Article II power to manage the executive branch workforce. The court's reasoning, in essence, seems to treat this Article II power as superior to Congress's statutory schemes.
Meaning the president's power trumps the laws Congress passed.
That appears to be the implication. The reasoning suggests that preventing the president from removing personnel involved in shaping or executing policy unconstitutionally burdens his ability to take care that the laws be faithfully executed. This creates a massive loophole in the merit system, making virtually any job that could be described as policy influencing vulnerable.
And what about that OPM rule from 2024, the one trying to protect employees?
Gone. This ruling simultaneously neutralized those previous protections. That April 2024 OPM rule, explicitly designed to uphold civil service protections by clarifying that career employees couldn't be stripped of safeguards just by moving their jobs. The Supreme Court's decision, by validating the president's executive order, rendered that protective regulation entirely moot.
So it cleared the path completely?
Completely. Cleared the path for its immediate rescission and the implementation of this new, radically altered employment framework.
So this ruling from the shadow docket not only clears the way, but immediately empowers a whole new employment framework. How exactly does this schedule policy career system work in practice? It's not just theoretical, it's a direct operational change.
Absolutely. With the Supreme Court's legal blessing now firmly in hand, the administration was empowered to immediately implement the framework laid out in its January 2025 executive order. This order reinstated and amended the original Schedule F concept, but under this new name, Schedule Policy Career.
Okay, Schedule Policy Career. What's the mechanism? How does it happen?
Oh, the mechanism for this transformation is centrally controlled, but its execution is carried out by the agencies themselves. The executive order directs the heads of all executive departments and agencies to conduct a thorough review and identify every position that could potentially be deemed of a confidential, policy-determining, policy-making, or policy-advocating character.
Based on that newly expanded definition.
Exactly. These agency heads must then submit lists of these identified positions to the Director of the Office of Personnel Management, the OPM, petitioning for their conversion into this new schedule policy career.
And the criteria for deciding who goes on that list.
That's the key. The criteria for inclusion in this new schedule are intentionally broad and subjective. This breadth ensures that a truly vast number of jobs across the federal government could be targeted for reclassification.
Can you give some examples?
Sure. The executive order lists several characteristics for consideration. Things like substantive participation in the advocacy, development, or formulation of policy, and that explicitly includes regulations and guidance. Or engaging in substantive policy-related work within an agency or component primarily focused on policy. The supervision of attorneys. Even the supervision of other employees who are themselves in scheduled policy career positions.
That sounds like it could cover a lot of ground.
It does. But there's an even more powerful sweeping provision, a catch-all. It allows for the inclusion of any other duties that the OPM director, after consultation with the White House, deems appropriate for conversion.
Wow. So basically, anything the OPM director and White House decide fits.
That final provision grants the administration virtually unlimited discretion to expand the scope of this new schedule, far beyond what might traditionally be considered a policy-making role.
So what are we talking about in terms of numbers? How many people could be affected?
Well, the exact number is still largely unknown. But experts and even proponents of the plan have estimated it could apply to a staggering range, anywhere from 50,000 to potentially hundreds of thousands of federal workers.
Hundreds of thousands?
Yes. To put that in perspective, that could be anywhere from 2% to over 10% of the entire federal civilian workforce, excluding the Postal Service. It's a huge potential pool.
That's massive.
And here's a particularly unsettling detail that came out from the plan's creators. They explicitly noted that it may not even be necessary to actually fire all these individuals. They suggested that the mere threat of at-will termination might be sufficient.
Sufficient for what?
Sufficient to produce the desired behavior change across the entire federal workforce, compelling compliance and loyalty without needing to initiate mass dismissals. The psychological impact of working under such a constant threat, well, it cannot be overstated.
So let's break this down. What does this reclassification really mean for the individual federal employee? What's the practical day-to-day difference between for cause and at-will employment for a federal worker who suddenly finds themselves under this new schedule policy career framework?
It is a fundamental and devastating stripping of legal rights. That's the bottom line. The reclassification of a federal employee from competitive or career-accepted service to a scheduled policy career position fundamentally transforms a protected professional into an at-will employee. It profoundly alters the very nature of their employment, practically overnight.
So, remind us, for cause versus at will.
Right. Under the traditional for-cause system, which previously applied to most non-probationary career, federal employees' termination could only occur for specific documented reasons. We're talking about things like poor performance, genuine misconduct, or a legitimate reduction in force due to budget cuts. And that system was, as we discussed, buttressed by robust due process and appeal rights, ensuring accountability and fairness.
Okay, and at will.
In stark contrast, at-will employment, the default for most private sector jobs, means an employer can terminate an employee for any reason, or even no reason at all, as long as it's not explicitly illegal, like discrimination based on a protected class.
So, for a federal employee moved to schedule policy career,
it means the immediate loss of the most critical protections of the merit system. They would no longer be entitled to 30 days advance notice of removal. There would be no right to formally respond to charges against them. And most crucially, they would lose their fundamental right to appeal an adverse action to the Merit Systems Protection Board, the MSPB.
no appeal.
No appeal. The shield against arbitrary, unfair, or politically motivated firing is entirely removed. They can be fired on the spot with no real explanation required and no avenue for independent review.
But the order says they don't have to politically support the president, right?
Yeah. Yes. The executive order attempts to provide a thin veneer of legality and reassurance by stating that employees are not required to personally or politically support the current president or the policies of the current administration. However,
There's a but.
there's a big but. This disclaimer is immediately followed by a crucial overriding caveat. Employees are required to faithfully implement administration policies to the best of their ability. Failure to do so is grounds for dismissal.
Faithfully implement. That sounds like it could mean anything.
It essentially establishes a de facto loyalty test not a true standard of performance, all under the guise of accountability. The distinction between political support and faithful implementation is legally porous and in practice often meaningless when the president and his appointed loyalists are the sole arbiters of what constitutes faithful.
Can you give an example?
Sure. Imagine for a moment an employee who provides objective, data-driven analysis that happens to contradict a politically preferred policy.
Right.
Or a scientist who presents inconvenient research findings about, say, climate change or public health that don't align with the desired narrative. Or even a lawyer who raises legitimate legal objections to a proposed agency action.
Okay.
Under this new system, all could easily be deemed as failing to faithfully implement the administration's agenda. Their recourse. Absolutely non-existent. This forces a stark choice between exercising apolitical, expert judgment, the very core value of the merit system, and maintaining one's livelihood.
So speak your mind based on your expertise or keep your job.
That's the choice. The practical effect is to profoundly chill dissent, compel unquestioning compliance, and demand a level of fealty that is functionally indistinguishable from personal political loyalty. It undermines the very oath federal employees take to uphold the Constitution, not just the directives of a single administration.
This isn't just about individual jobs, then. It's really about the very functioning of our entire government. The impact stretches far beyond the immediately affected employees, leading to a profound destabilization across federal agencies.
You've hit on a critical point. The immediate and, frankly, most predictable consequence of implementing such a large-scale at-will employment system within the federal government is a catastrophic loss of institutional expertise and memory.
A brain drain.
A massive brain drain. We're talking about a potential mass exodus, either through direct termination or preemptive resignation by those unwilling to work under such conditions of experienced, nonpartisan professionals. This would effectively hollow out federal agencies, severely degrading their capacity to perform their core missions, which are often complex, technical, and require deep institutional knowledge.
So it weakens the government's ability to function.
It would cripple the government's ability to engage in long-term functions that are absolutely essential to national well-being and security. Think about it. The federal government relies on a deep reservoir of specialized knowledge built over decades, sometimes generations.
Like what kind of expertise are we talking about?
Well, the expertise of scientists at the National Oceanic and Atmospheric Administration, NOAA, who forecast severe weather, track hurricanes, monitor ocean health, epidemiologists at the Centers for Disease Control and Prevention, CDC, who are on the front lines tracking and combating pandemics, engineers at the Department of Transportation, ensuring the safety of our bridges, roads, air traffic control, economists at the Treasury Department managing the nation's finances.
These aren't political jobs.
Not at all. They are highly technical positions that require years, often decades, of dedicated experience and continuity. A 2022 academic review explicitly warned that converting career employees to an at-will status and removing their civil service protections is, likely to degrade government performance, leading to a less effective and less responsive government.
And this affects future hiring too, right?
Absolutely. The damage extends far beyond the loss of current employees. The pervasive politicization of the civil service would have a profound chilling effect on future recruitment. The promise of a stable, merit-based career offering meaningful public service has historically attracted highly qualified individuals to government, often at salaries lower than they could command in the private sector.
Take away that stability.
Take away that foundational job security, and it would make it nearly impossible to recruit and retain top-tier talent in critical fields. Instead, we could see a government increasingly staffed by less experienced, less qualified individuals, or maybe worse, those selected primarily for their political allegiance rather than their competence.
Which leads to?
Over time, it inevitably leads to a downward spiral of declining government efficacy, poorer policy outcomes, delayed or failed program implementation, and a severely diminished ability to respond effectively to national crises, whether they are economic, environmental, or security-related.
It's easy to see how such a system could lead to an information vacuum. What happens when the very people who are supposed to speak truth to power, to offer objective analysis, are afraid to do so?
That's precisely the concern. A core, often unacknowledged function of the professional civil service is to provide objective, evidence-based, and sometimes unwelcome advice to political leaders. This ensures that policy decisions are grounded in facts, data, and a clear-eyed assessment of potential consequences, rather than just ideology or political expediency alone.
And at-will employment silences that.
It would effectively silence this crucial channel of apolitical counsel. When a federal employee's job security depends on the subjective approval of their political superiors, the incentive structure shifts dramatically. Instead of speaking truth to power, the new incentive is to tell power what it wants to hear, or simply to stay silent.
The chilling effect you mentioned earlier.
Exactly. The threat of being fired for failing to faithfully implement administration policies would create a powerful, pervasive chilling effect across every single federal agency. Consider these scenarios. A scientist whose climate research directly contradicts the administration's preferred energy policy might be silenced or fired. An intelligence analyst whose objective assessment of a foreign threat doesn't align with the desired political narrative could face immediate termination. A budget officer pointing out the infeasibility or massive cost overruns of a pet project could be dismissed without recourse.
So crucial information just doesn't get to the decision makers.
Exactly. In all these cases, critical, objective information that leadership needs to make sound decisions would be withheld or distorted. The result is a government that operates in an information vacuum, deprived of the very expertise it needs to govern effectively and avoid costly mistakes.
What about whistleblowers? Don't they still have protections?
Well, this environment would also render whistleblower protections functionally obsolete. While the laws designed to protect employees who report waste, fraud, or abuse might technically remain on the books, they would be easily circumvented.
How so?
An employee who reports questionable activity could simply be fired under the pretext of being a poor fit or not a team player, and without the right to appeal to the MSPB, there would be no independent arbiter to determine the true retaliatory motive.
So the protection exists on paper, but not in practice.
Pretty much. This would foster an atmosphere where loyalty to the president's personal or political agenda, rather than to the Constitution and the laws of the United States, becomes the paramount virtue for survival. Federal officials take an oath to uphold the Constitution, a reminder that their ultimate allegiance is to the rule of law, not to the occupant of the White House. An at-will system directly undermines this foundational principle, replacing it with a loyalty test.
This leads to an alarming prospect: the potential weaponization of federal agencies. If these checks and balances are weakened, what prevents the vast powers of government from being used for purely partisan purposes?
You're pointing to perhaps the most dangerous national implication of a politicized civil service. Federal agencies wield enormous authority over the lives and livelihoods of Americans, granting licenses, contracts, enforcing regulations, initiating investigations. The merit system was meticulously designed to ensure this immense power is exercised impartially, based on law, evidence, and public interest, not political favor or retribution.
Removing that safeguard.
Removing that safeguard invites abuse on a truly massive scale. An administration empowered to fire disloyal employees at will could exert immense, unprecedented pressure on officials at key agencies to target political adversaries and reward political allies.
What kind of scenarios are we talking about?
One can envision chilling scenarios. The Internal Revenue Service, for example, being directed to launch politically motivated audits against critics of the administration, while perhaps overlooking favored groups. Or the Department of Justice being pressured to open, expedite, or even close investigations based purely on partisan considerations rather than the merits of the case. The Environmental Protection Agency could be told to relax enforcement against favored industries or corporations, maybe those that are politically connected, while aggressively targeting others perceived as adversaries. Federal grants, contracts, loans, even crucial disaster relief funds could potentially be steered toward politically friendly states, districts, or individuals, essentially using public funds as political tools.
So government power used for political gain or punishment.
Exactly. This transformation of federal agencies from impartial arbiters of public law into instruments of personal and political power represents a fundamental threat to American democracy itself. It undermines the principle of equal justice under law, where everyone is treated fairly regardless of their political affiliation. It erodes public trust in the basic fairness and integrity of government institutions.
And moves us away from a government of laws.
Ultimately, it moves the nation away from a government of laws, where everyone is bound by the same rules, and toward a government of men, where the exercise of state power is contingent on allegiance to the current ruler, This is a very slippery slope away from democratic principles.
And tragically, this impact won't be evenly distributed across the population. Our sources suggest some communities, some demographics, will feel this much more acutely than others.
That's a crucial, often overlooked dimension of this policy shift. The dismantling of the merit-based civil service would not affect all communities equally. It would have a particularly devastating and disproportionate impact on women and people of color.
Why them specifically?
Because for whom the federal government has historically been a crucial engine of economic opportunity and upward mobility. For decades, the objective, merit-based hiring and promotion criteria of the civil service have provided a vital shield against the conscious and unconscious biases that can unfortunately permeate private sector employment.
So the federal government offered a fairer shot.
In many ways, yes. This objective system has helped make the federal workforce a significantly more diverse and representative institution than many other sectors of the economy. For instance, the federal government has often been a leader in equal opportunity employment.
So attacks on the workforce hit these groups harder.
Consequently, attacks on the federal workforce and its foundational protections disproportionately harm women and people of color, who are highly represented within its ranks, particularly in stable middle-class positions. The shift to an at-will system, where hiring and firing decisions can be based on subjective criteria like fit or loyalty, could easily reintroduce the potential for these same biases to influence employment decisions.
Reversing progress.
Potentially reversing decades of progress. The hard-won gains in representation and economic security for these communities could be rapidly reversed, pushing them back into less secure, lower-paying jobs, or even unemployment. The loss of these stable, middle-class federal jobs wouldn't just impact the individual employees, it would have a profound ripple effect on their families and communities, destabilizing a key pathway to economic advancement that has been instrumental for generations.
So equal opportunity gets replaced by what? Connections? Loyalty?
The promise of equal opportunity, a core tenet of the merit system, would be replaced by a system where personal connections and perceived political allegiance could once again become the primary currency for career advancement, to the distinct disadvantage of historically marginalized groups who have fought so hard to achieve these positions.
While the damage will undoubtedly be felt nationwide, our sources highlight a place where it will fall with calamitous and truly disproportionate force: the U.S. Virgin Islands. This is where the theoretical national implications become devastatingly real on the ground.
Indeed. To truly grasp the catastrophic potential of the Supreme Court ruling, we absolutely must look beyond the national landscape to a specific place where its negative impacts would be exponentially amplified: the U.S. Virgin Islands, or USVI.
Why the USVI in particular?
Well, the territory's unique political status, combined with its profound economic fragility and its geographic exposure to natural disasters, creates what can only be described as a perfect storm of vulnerability. This makes it a critical, perhaps even chilling case study in the dangers of a politicized federal workforce.
Explain that unique political status.
Okay. The USVI is classified as an organized, unincorporated United States territory. This political status places it directly under the plenary authority of Congress and under the administrative oversight of the U.S. Department of the Interior's Office of Insular Affairs.
And the consequence of that?
The most profound consequence is the political disenfranchisement of its residents. Despite being U.S. citizens, Virgin Islanders cannot vote for the President of the United States, and they have no voting representation in the U.S. Congress. They elect a single non-voting delegate to the House of Representatives.
No real say in federal policy that affects them.
Virtually none. This fundamental lack of political power means the USVI has almost no ability to influence the federal policies that govern it, or to push back effectively against actions originating in Washington that threaten its well-being. And this political powerlessness is compounded by severe and persistent economic and fiscal challenges.
Like what?
The territorial government struggles with high levels of public debt, over $2.2 billion, a staggering 50% of its GDP back in 2021. Furthermore, its public pension system, the Government Employees Retirement System, known as GERS, is one of the most severely underfunded in the entire United States.
How bad is it?
It has been teetering on the brink of insolvency for years, with projections by actuaries that it could be completely depleted by 2025. That threatens the retirement security of nearly 19,000 current and former public employees.
Wow. And on top of that, dependence on the federal government.
Crucially, yes. The USVI's economy is profoundly dependent on the federal government. Federal spending is a primary driver of the territory's GDP. Government consumption accounts for roughly 28% of the total economic output. The territorial budget also relies heavily on federal program funds and disaster relief aid to provide even basic services and, crucially, to recover from the frequent and devastating hurricanes that strike the region.
So put it all together.
This unique combination, political disenfranchisement, deep economic dependence, and inherent geographic vulnerability makes the USVI exceptionally susceptible to any disruption in the stability and functionality of the federal government. It's truly a scenario where national policy has outsized, localized consequences.
What's truly striking here is just how integrated the federal presence is in the daily life of the Virgin Islands. It's not just a few remote offices, it's woven into the very fabric of the community. So for our listeners, what does that federal footprint actually look like on the ground?
It's far more extensive and essential than people often realize. The federal government is not an abstract entity in the U.S. Virgin Islands. It's an integral, indispensable part of the territory's daily governance, economy, and social fabric, while the absolute number of federal employees is modest compared to the mainland.
How many are we talking about?
Well, the Office of Personnel Management's March 2024 count noted 433 onboard federal civilian employees that excludes postal workers, military contractors, most legislative and judicial folks. But their functions are of outsized importance. These few hundred individuals perform absolutely vital functions that directly impact the lives of Virgin Islanders.
Okay, give us some examples. Which agencies are key?
Let's break down some of the key federal agencies and their mandates in the USVI. First, and maybe most visible, the Federal Emergency Management Agency, FEMA. Their core mandate: disaster preparedness, response, recovery, long-term hazard mitigation.
Absolutely critical in Hurricane Alley.
Critical doesn't even cover it. FEMA manages billions of dollars in disaster aid post-hurricanes. They partner directly with the local Virgin Islands Territorial Emergency Management Agency, VTEMA, on everything from evacuation planning to rebuilding damaged infrastructure, the power grid, roads, public buildings. Without their continuous experienced presence, the islands are incredibly vulnerable to the next storm. Imagine rebuilding after a Category 5 hurricane without experienced federal project managers on the ground. It would be catastrophic.
Okay, FEMA is huge. Who else?
Then there's the Department of the Interior, DOI, and specifically its Office of Insular Affairs, OIA. Their primary mandate is general federal administration of the territory, providing crucial financial and technical assistance. They serve as the primary liaison, the direct line between the territorial government and the federal government in Washington.
The main link.
Essentially, yes.
Huh.
They oversee federal funding and provide technical support for governance, economic development, resource management. They are the lifeline connecting the USVI's unique status to federal support.
What about environmental protection? That must be important for islands.
Absolutely crucial. The Environmental Protection Agency, EPA. Their mandate is the enforcement of federal environmental laws, protecting air, water, land resources. The EPA partners directly with the local Department of Planning and Natural Resources, DPNR, to ensure safe drinking water, manage hazardous waste, oversee critical cleanup efforts.
So public health and tourism both rely on the EPA.
Fundamentally, both public health and the territory's tourism-based economy, which relies heavily on a pristine environment. And, disturbingly, as part of broader cost-cutting measures, the EPA has already terminated the lease for its office in the Virgin Islands.
They closed the office.
Terminated the lease, yes. And its regional operations in nearby Puerto Rico are also facing significant cuts. This means fewer federal environmental inspectors and engineers on the ground for a territory with delicate ecosystems and pressing public health concerns like wastewater management and drinking water quality.
That's worrying. Okay, who else? HUD, housing.
Yes, the Department of Housing and Urban Development, HUD. Their mandate is administering housing assistance and community development programs. HUD provides essential funding for affordable housing, Section 8 vouchers, public housing programs, and crucially, they allocate billions in community development block, grant disaster recovery, CDBG-DIR, funds for rebuilding efforts post-hurricanes. These funds are literally rebuilding homes and communities across the islands.
Billions for rebuild.
Billions. Without the experienced federal personnel to manage these complex grants, that money could be held up, leaving damaged homes unrepaired and communities in limbo.
What about the national parks? The 6 has several beautiful ones.
Yes, the National Park Service, NPS, which falls under DOI, is also facing significant threats. The Department of the Interior has reportedly been directed to prepare sweeping cuts, with internal warnings of gutting everything within the Park Service.
Gutting everything.
That's the reported internal language. In the USVI, this directly threatens iconic units like Virgin Islands National Park on St. John, Buck Island Reef National Monument, Christian Mested National Historic Site, and Salt River Bay National Historical Park and Ecological Preserve, all on St. Croix. These parks are not just natural and cultural treasures. They are pillars of the tourism industry, magnets for visitors, sources of immense local pride.
Are some parks more vulnerable than others?
It seems so. Smaller parks, like Salt River Bay, are apparently especially vulnerable. The Interior Secretary has reportedly labeled low visitation sites as cost centers. This puts park rangers, marine biologists monitoring critical coral reefs, archaeologists preserving ancient sites, vital maintenance crews, all at risk.
And the consequences?
The consequences could include less visitor services, compromised public safety in remote areas, longer maintenance backlogs, even partial closures of these national treasures. It imperils both cultural preservation efforts and the health of crucial ecosystems. We've seen similar brain drain concerns in the Alaska Regional Office, where reports suggest a third of employees were pressured to retire.
So FEMA, DOI, EPA, HUD, NPS, any others?
Beyond these, many other federal offices contribute. The USDA, for example, supports farmers, conservation efforts, provides grants vital for the agricultural sector, potential for reductions in technical assistance if field offices are consolidated. NOAA collaborates on crucial marine research and weather monitoring. While law enforcement roles like Customs and Border Protection and TSA are generally seen as less likely to be cut due to border security priorities, it's the domestic administrative agencies, those providing direct services and expertise, that are primarily targeted.
And the overall impact of losing experienced people there?
The overall impact of replacing experienced, locally knowledgeable personnel with transient, potentially less qualified, politically appointed individuals directly threatens the essential service delivery that Virgin Islanders rely on every single day.
Given this deep federal footprint, what does this all mean for the USVI's already delicate economy, which relies so heavily on federal activity and funding?
For the fragile economy of the U.S. Virgin Islands, the implementation of widespread at-will federal employment would trigger a severe and immediate economic shock, with cascading consequences. The initial impact would be the direct loss of salaries from any terminated federal employees.
Those middle-class jobs we talked about.
Exactly. Yeah. These are stable middle-class incomes. Every federal employee in the USVI is a taxpayer, a consumer, often a pillar of their community. The loss of even dozens of these good-paying jobs would immediately impact household incomes and local spending power. An EPA engineer or a park ranger losing their job might cut back on local purchases, hurting small businesses, or they might even relocate to the mainland, meaning the territory loses a skilled resident and a tax contributor.
And in small island communities.
In small island communities like those in the USVI, even a handful of job losses can resonate significantly throughout the entire local economy.
But the indirect effects sound even worse.
They are potentially far more devastating, yes. The primary economic threat stems from the inevitable chaos, delays, and sheer inefficiency that a politicized and inexperienced federal workforce would introduce into the administration of crucial federal funds.
Especially the hurricane recovery funds.
Absolutely. The USVI is currently in the midst of a multi-billion-dollar recovery from the devastating 2017 hurricanes, a massive, ongoing process entirely dependent on the steady and confident flow of funds from FEMA, HUD, and other agencies. A purge of experienced federal project managers, grant administrators, technical experts who understand the nuances of territorial recovery that would effectively grind this process to a halt.
Projects stop. Payments stop.
Projects would be delayed. Payments to local contractors could cease. The entire recovery effort would be thrown into profound jeopardy, leaving communities literally broken.
And the impact on the local government's finances.
Calamitous. This disruption of federal cash flow would, in turn, have a calamitous effect on the territorial government's own precarious finances. The government of the Virgin Islands, the GVI, relies heavily on this federal activity to generate local tax revenue through consumption and other economic activities and to sustain its operations. A sharp decline in federal spending would blow a massive hole in the GVI's already strained budget, making it even more difficult to meet its obligations, including paying its own employees and delivering essential services.
And the pension crisis.
This would also place immense pressure on the already failing government employees' retirement system, the GERS pension system. We mentioned its projected insolvency by 2025. The system's survival depends on the GVI's ability to make its contributions. An economic crisis triggered by federal dysfunction would likely push the pension system over the edge, wiping out the retirement security for thousands of Virgin Islanders and creating a profound social crisis that would ripple through every family.
So it's not just about the federal payroll, but broader cuts too.
Exactly. Beyond the immediate payroll and specific project funds, broader federal spending cuts extend to overall agency budgets, meaning fewer federal dollars for projects, grants, and services across the board. Governor Albert Bryan Jr. has already warned that federal support is shifting and that the safety nets many of our families rely on are under threat, pointing to proposed federal budget reductions in Medicaid, SNAP, food stamps, housing assistance as looming dangers for the most vulnerable. Delegate Plaskett also raised alarms about a temporary pause on federal grants and loans, highlighting the vulnerability of community grants, education funds, infrastructure loans.
So the overall picture for the USVI economy is
A profound contraction of its fragile economy, compounding the fiscal challenges from the hurricanes and the pandemic. This would also put immense pressure on the territorial government to somehow fill these gaps, despite its severely limited revenue and borrowing capacity.
beyond the economic fallout, the potential degradation of lifeline services is a direct, immediate threat to the safety and well-being of Virgin Islanders. What's the concrete impact there on their daily lives?
The degradation of the federal workforce would directly compromise the lifeline services that protect the health, safety, and well-being of Virgin Islanders in a very tangible way. Let's start with disaster management, which is paramount in the USVI.
Right, Hurricane Alley.
Its location makes it one of the most disaster-prone jurisdictions in the United States. The territory's emergency management system is explicitly built on a vital, day-to-day partnership between the local VITAMA and the federal FEMA. This isn't just theoretical. It's hands-on operational collaboration involving joint planning, training, rapid response when a storm hits.
And experience matters there.
Immensely. Experienced FEMA officials possess invaluable territory-specific knowledge. They understand the unique logistical challenges of moving resources between islands, the intricacies of the local supply chain, the specific vulnerabilities of the territory's infrastructure, like its aging power grid.
So replacing them with political appointees.
Replacing these seasoned professionals with political appointees who lack this localized expertise would be, quite simply, a recipe for disaster. In the face of the next major hurricane, a breakdown in the FEMA-VIDEMA partnership could lead to catastrophic failures in delivering basic necessities like food, water, medical care, emergency power. We're talking about direct impacts that could cause preventable loss of life and prolonged suffering for residents already struggling to recover.
What about environmental protection? You mentioned the EPA office closing.
Yes, and the EPA's role in the USVI is absolutely critical to public health. The agency works closely with the local DPNR to enforce crucial federal laws like the Clean Water Act and the Safe Drinking Water Act. This addresses pressing issues such as wastewater management and safe sewage disposal, tackling contaminants in the public water supply. Remember the recent emergency declaration over dangerous lead and copper levels? A weakened or politicized EPA, unwilling or simply unable to conduct rigorous oversight and enforcement, could allow existing environmental hazards to fester or new ones to emerge unchecked. This directly threatens the health of residents, particularly children, and also severely impacts the viability of the tourism industry. And with the EPA office closed, the burden shifts entirely to the already under-resourced territorial DPNR, which simply doesn't have the capacity to fill that void.
And the social safety net.
Consider the social safety net. Federal social programs are a critical lifeline for many low-income Virgin Islanders, providing essential support for food, housing, healthcare. However, the territories have long been subject to discriminatory federal policies, historical caps on Medicaid funding, reduced access to programs like Supplemental Security Income, SSI, for the disabled and elderly. These policies already create a second-tier system.
And this could make it worse.
An at-will federal workforce could compound this existing injustice. Politically motivated or simply incompetent administrators at HUD, USDA overseeing SNPATE, or Health and Human Services could create new arbitrary barriers for USVI residents attempting to access these already limited benefits. This could push vulnerable families, children, the elderly, the disabled, even deeper into poverty, with very real human consequences.
This all raises a deeply unsettling question. What happens to the essential long-term working relationships between local and federal agencies when the federal side is destabilized by these sweeping changes? These aren't just bureaucratic entities, they're partnerships built on trust and continuity.
That's a crucial observation, because the day-to-day effectiveness of federal programs in the USVI, and indeed across the nation, hinges on a complex, collaborative web of relationships between territorial agencies and their federal counterparts. The long-term recovery, economic development, resilience of the islands depend profoundly on the trust, shared institutional knowledge, personal connections built over years between dedicated officials at FATIMA and FEMA, or DPNR and the EPA, or the USVI Department of Health and the federal HHS.
So it's about people knowing each other, trusting each other.
Exactly. This partnership is essential for everything from co-developing the territory's hazard mitigation and resilience plan, which determines how billions in recovery funds are spent, to managing the day-to-day administration of federal grants for schools, roads, social services.
And a purge breaks those connections.
A purge of experienced federal staff under an at-will system would, quite literally, sever these vital relationships. Trusted, long-serving federal partners with deep local knowledge who understand the unique culture, logistical challenges, specific needs of the Virgin Islands would be replaced by a rotating cast of unknown, potentially transient political appointees.
Leading to
shattered institutional memory, widespread confusion, duplication of effort, a complete breakdown in strategic planning. The collaborative process, which relies on mutual respect and shared goals, would inevitably be replaced by a top-down, politically driven dynamic that is largely unresponsive to genuine local needs and realities.
And this hits the USVI harder because it's smaller.
The severity of this impact is disproportionate for the USVI, precisely because of the small number of federal employees stationed there. The removal of even a handful of key, long-serving individuals wouldn't merely be a brain drain, as seen in larger mainland agencies. It would be what some observers describe as a decapitation strike against federal capacity in the territory.
A decapitation strike.
Think about it. Each major federal agency may only have a few senior personnel on the ground in the USVI who are deeply familiar with its unique challenges. Firing the lead FEMA recovery coordinator or the senior EPA enforcement officer responsible for clean water, or the chief DOI liaison who understands the island's political nuances. That would leave a knowledge and leadership vacuum that a new, often temporary appointee from the mainland could not possibly fill for months or even years.
Paralyzing the federal function there.
Effectively paralyzing the federal government's ability to function effectively in the territory, with devastating consequences for the people of the U.S. Virgin Islands who depend on these services for their health, safety, and economic well-being.
So, given all this, what stands out to you about the immediate community response on the ground in the USVI to these developments? How are people actually reacting to this profound threat to their daily lives?
Well, there are already clear and palpable signs of local pushback and deep alarm. Reports have emerged of current and former federal employees in the USVI rallying against these proposed cuts, arguing passionately that these drastic reductions harm essential services that are absolutely vital for the island's survival and well-being.
So people are speaking out.
They are. While specific details on the scale of immediate organized resistance might vary, it's not surprising to see this. Many Virgin Islanders have family members or themselves have served in U.S. federal jobs as part of military or civil service careers, and seeing colleagues summarily terminated, or the threat of it, is deeply unsettling and directly impacts their communities. Local chapters of federal unions, like those representing TSA workers at the airports or National Park Service rangers, may have organized demonstrations or petitions raising their voices against these policies. This activism indicates that the territory's residents are not passive spectators. They are actively voicing fears that losing federal workers means losing neighbors, mentors, pillars of their tight-knit communities.
What about the Park Service cuts specifically?
The potential National Park Service cuts, for instance, are worrying not just the employees themselves, but also park volunteers, local tourism operators, conservation leaders who work closely with them. Cultural preservation efforts, like protecting historic architecture in Christian Neigstead or archaeological sites at Salt River Bay, are already being disrupted by the loss of key staff, according to local news reports. This leaves vital projects in limbo and communities anxious about the fate of their rich heritage.
And the broader impact on the community's identity.
Beyond this, there's a broader social and community impact that touches on the USVI's unique identity. The Virgin Islands already grapples with its semi-colonial status, where U.S. citizens cannot vote for president and have limited congressional representation. The spectacle of a Washington-driven mandate unilaterally slashing local jobs and services with little input from the territory can feed a profound sense of powerlessness and even resentment. If cherished national parks close or federal offices shutter with little notice, it reinforces the feeling that the territory's needs are overlooked or disregarded in national decisions. This could have a significant psychological and political impact, potentially invigorating long-standing calls for greater local autonomy or full representation.
And the practical day-to-day impacts.
At a very practical level, residents might immediately encounter new hurdles. Imagine longer wait times at the Lone Social Security Administration field office if staff are pared down, or difficulty getting information about federal student aid or small business administration loans if those outreach positions are eliminated. After past hurricanes, federal agency personnel played absolutely huge on-the-ground roles in recovery efforts, from processing claims to rebuilding infrastructure. If those agencies are understaffed, or if critical regional offices like FEMA's Caribbean Division face cuts, the disaster preparedness and response capacity in the USVI could be severely compromised. This is not just an inconvenience, it's a life and death matter in a hurricane-prone area where federal support is a literal lifeline.
So the partnership fraying is felt everywhere.
Ultimately, yes. The local economy and society depend heavily on a functional, trusting partnership with federal agencies, and any fraying of that bond will be felt in every aspect of daily life for Virgin Islanders.
This whole situation sounds incredibly grim, but our sources also discuss potential pathways for mitigation and strategies to move forward. What actions can be taken, starting with Congress, to push back against this fundamental change?
Well, it is grim, but not hopeless. The Supreme Court's ruling and the subsequent implementation of at-will federal employment represent a systemic threat, yes, but countering this requires a multi-pronged, coordinated strategy across various levels. For Congress, as the legislative body that originally designed and built the merit-based civil service, it holds the most powerful tools to counteract the executive branch's newly validated authority.
So what's the first step for Congress?
A legislative response must be swift and decisive to protect the civil service. First, Congress should prioritize the passage of a new and robust Saving the Civil Service Act. This new law must go beyond prior versions and be specifically drafted to directly address and effectively nullify the court's expansive ruling.
How would it do that?
It should, for example, statutorily define terms like confidential, policymaking, or policy advocating, with extreme narrowness, ensuring that these definitions cannot be broadly interpreted by future administrations. Crucially, it must explicitly codify the Due Process and Merit Systems Protection Board, MSPB, appeal rights for all career federal employees, regardless of how their positions might be classified in different service schedules. This would create a strong statutory bulwark against any attempt to implement widespread at-will employment for career civil servants.
Okay, a new law. What else can Congress do?
Second, Congress should utilize the Congressional Review Act, or CRA. That's a legislative tool often used to overturn federal regulations. As soon as the Office of Personnel Management, OPM, finalizes a new rule to implement the Schedule Policy Career Framework, Congress should use its authority under the CRA to pass a resolution of disapproval.
What would that achieve?
It would not only nullify the regulation, but would also prevent the executive branch from issuing a substantially similar rule in the future, buying crucial time for a more permanent legislative fix like the act we just discussed.
An oversight.
And third, absolutely critical, Congress needs to conduct aggressive and sustained oversight. Congressional committees with jurisdiction over the civil service and territorial affairs must hold immediate and ongoing oversight hearings. These hearings should serve to publicly document the negative impacts of the new policy, creating a clear and damning public record of government dysfunction, waste, and potential abuse. Testimony should be vigorously solicited from former federal employees who have been affected, from good government groups, and critically, from officials representing vulnerable jurisdictions like the U.S. Virgin Islands to highlight the real-world consequences.
And what about the federal employees themselves, whose careers and livelihoods are now directly on the line? What actions can they take to proactively defend themselves in this new and uncertain landscape?
While their traditional statutory protections are being dismantled, federal employees are certainly not entirely without agency or recourse. They must adopt a strategy of proactive self-defense to protect themselves and, importantly, to document the damage being done to their agencies and the public good.
So document everything.
First and foremost, yes. Meticulously document their performance. All federal employees, particularly those in roles that could even remotely be deemed policy influencing, should immediately begin to keep detailed personal records of their job performance. This includes copies of their performance reviews, official commendations, records of successful projects they've completed, any written evidence of their adherence to professional, apolitical duties. This documentation creates a factual record of merit that may be useful in any remaining, albeit limited, legal challenges, and certainly for their professional reputation.
And use the channels that still exist.
Secondly, exactly, employees should diligently utilize any remaining recourse channels. While at-will status eliminates appeals for arbitrary firing, it does not eliminate protections against explicitly illegal acts. For instance, employees are still protected from discrimination based on protected class status, and whistleblower protections, though undermined, technically remain on the books.
So report illegal actions.
Yes. Employees should continue to report any instances of political coercion, illegal orders that violate law or regulation, or discrimination to their agency's Office of Inspector General, OIG, or the Office of Special Counsel, OSC. Creating an official record of prohibited personnel practices is a critical, if imperfect, line of defense for these individuals. This documentation can form the basis for future legal action, even if their direct appeal rights are gone.
Given its unique vulnerability and dependence on federal services, what specific strategies can the government of the U.S. Virgin Islands adopt for survival and to mitigate the damage in this new landscape? What can they do on a local level to push back or adapt?
For the U.S. Virgin Islands, the stakes are truly existential, as we've discussed. The territorial government must mount a robust, multifaceted advocacy and resilience campaign to navigate this crisis. First, they should immediately form a territorial coalition for targeted advocacy.
Team up with other territories.
Exactly. Forging a strong alliance with the governments of other U.S. territories, Puerto Rico, Guam, American Samoa, the Commonwealth of the Northern Mariana Islands. This coalition should then launch a high-profile, aggressive advocacy campaign in Washington, D.C., specifically designed to educate Congress and the broader American public about the unique and catastrophic risks the new federal employment policy poses to the territories.
How should they frame that message?
The campaign's messaging should frame the issue not merely as one of bureaucratic procedure or individual jobs, but as a profound threat to national security by destabilizing strategic U.S. locations and a precursor to humanitarian crises that will ultimately require massive, costly federal interventions. This would emphasize the national interest in maintaining a stable civil service in the territories.
So, appeal to national security and potential costs. What about local actions?
Second, the government of the U.S. Virgin Islands, the GVI, must accelerate its efforts to develop local resilience and contingency plans. Recognizing that federal support may become unreliable or politicized, the GVI must prioritize building its own local institutional capacity.
Strengthening their own agencies.
Yes. This includes investing in and actively seeking independent grants for its territorial agencies like VTEMA and DPNR, empowering them to fill some of the gaps left by a diminished federal presence. They should also strengthen mutual aid agreements with neighboring Caribbean nations, creating regional support networks for disaster response and other critical services. Furthermore, the GVI must develop concrete contingency plans for operating essential services with significantly diminished federal partnership and funding.
Planning for the worst, essentially.
Planning for a future where they might have to shoulder more responsibilities for everything from environmental monitoring to disaster recovery, even if resources are strained. It's also worth highlighting an interesting contrast here. USVI local laws and unions actually offer stronger civil service protections for territorial employees than the U.S. Constitution now seems to offer for federal workers under this new interpretation.
Interesting. So local government jobs might be more secure.
Potentially, yes. This means the territorial government may need to pick up significant slack, for example, by having local law enforcement take on more responsibilities on federal lands, or DPNR taking on even more environmental monitoring that was previously shared with the EPA.
And the political stance.
The legal and political stance of the USVI leadership is also crucial. Governor Albert Bryan Jr. and Delegate Stacey Plaskett have already publicly questioned such sweeping executive action. We can expect the USVI to actively support ongoing legal challenges, perhaps by filing amicus briefs in solidarity with other plaintiffs. Delegate Plaskett, despite being a non-voting member, can also play a vital role in pushing for specific territorial considerations and safeguards in any new legislation Congress might consider, ensuring the unique vulnerabilities of the islands are not overlooked.
And finally, what role can civil society, including public interest groups and legal advocates, play in the struggle to push back against these sweeping changes to the civil service?
Civil society organizations, public interest law firms, good government advocacy groups, Federal employee unions, they have an absolutely crucial role to play in leading the charge on both legal and public opinion fronts. Firstly, they must launch strategic litigation. Yes, legal challenges should be meticulously prepared and filed to fight the implementation of this at-will system on multiple fronts. Following the model of past successful lawsuits by groups like the National Treasury Employees Union, NTEU, litigation can challenge the reclassification of specific employees as arbitrary and capricious, argue that the new system violates remaining statutory protections against prohibited personnel practices, and seek to enjoin the policy's application in critical areas like public health and safety where disruption could cause irreversible harm. These legal battles will be complex and challenging, but they are a vital avenue for defense.
And public opinion.
Secondly, absolutely. These groups must drive a compelling national public education campaign. This entails a sustained, well-resourced public information campaign designed to counter the often misleading narrative of an unaccountable deep state.
How do they do that effectively?
The campaign should use compelling human interest stories to illustrate the vital, often heroic, non-political work that career civil servants perform every single day. Think of the food safety inspectors ensuring your groceries are safe, the scientists developing the next vaccine, the meteorologists forecasting hurricanes, the engineers maintaining infrastructure, the dedicated staff caring for veterans.
Humanize the civil service.
Exactly. By putting a human face on the civil service and clearly explaining the stakes for every American, how these changes impact their own safety, health, economic well-being, these groups can build the public and political will necessary to restore and strengthen the merit system. The struggle to defend the integrity of the civil service is thus inextricably linked to the well-being of the most vulnerable citizens and jurisdictions under the American flag.
We've taken a deep dive today into a profound transformation of American civil service and governance. The Supreme Court's decision, delivered on July 8, 2025, has essentially diminished a cornerstone of modern government. The foundational notion that federal employees serve the public interest, protected from political whims, and capable of providing objective expertise.
It really has shifted the ground beneath our feet.
It has. The balance of power has significantly tilted toward an emboldened executive branch, raising the specter of a unitary executive with sweeping, unprecedented control over the vast federal workforce. The practical ability of government to function effectively, to research critical vaccines, process essential benefits, manage beloved national parks, enforce vital laws, is now being tested as tens of thousands of experts face uncertainty or are forced to exit.
The consequences are potentially enormous.
And for the U.S. Virgin Islands, these national shifts are not just distant headlines. They will be felt directly in parklands, at kitchen tables, in the very halls of its government. The territory illustrates in microcosm why these civil service protections mattered so profoundly. They ensured continuity, professionalism, unwavering commitment in delivering federal services to all corners of the nation, far beyond partisan changes in Washington, D.C.
The canary in the coal mine, as the saying goes.
Exactly. As our sources compellingly noted, the USVI serves as the canary in the coal mine, demonstrating in vivid microcosm the cascading failures when professionalism and expertise are sacrificed for the sake of political control and loyalty. This deep dive really makes us consider a final provocative thought for all of us. What kind of government do we truly want? Do we want one that prioritizes personal political loyalty above all else, where expertise is secondary to allegiance? Or do we want a government that continues to uphold the principles of professionalism, continuity, and expert service for the good of all its people, especially its most vulnerable citizens and communities? What stands out to you most from this profound deep dive into the future of our civil service?
For me, it's the fragility. How decades of building a professional service can be undone so quickly, and the disproportionate impact on places like the USVI that rely on it most. It's a stark reminder.
It certainly is. Thank you for tuning in to the DGH News and Information Network. For more news, weather, and insightful information, be sure to visit dghradio.com online radio. You can also request to join our WhatsApp group where you'll get the news, weather, and other insightful information delivered right to your smartphone. To join, simply text JOIN DGH WhatsApp group to 1-315-898-1449. Please include a name in the text message, as you will receive a call to verify your membership request. We appreciate you listening. Remember to pronounce DGH News and Information Network properly, especially the DTH. Here's a quick look at our station schedule for those who want to stay informed throughout the day. Weather updates can be heard at the bottom of each hour daily, 30 minutes after each hour. FSN News follows 15 minutes later on the 45-minute mark. For other news, you can tune in 4 times daily. News from the USVI can be heard at 6 a.m., 12 p.m., 6 p.m., and 12 a.m. From the BVI, catch the news at 7 a.m., 1 p.m., 7 p.m., and 1 a.m. News from the wider Caribbean is reported at 8 a.m., 2 p.m., 8 p.m., and 2 a.m. And for U.S. and world news, tune in at 9 a.m., 3 p.m., 9 p.m., and 3 a.m. Historical feature stories come on at 10 a.m., 4 p.m., 10 p.m., and 4 a.m. And our program Democracy Now! Plays at 11 a.m., 5 p.m., 11 p.m., and 5 a.m., except on weekends when we feature other insightful topics. Remember, we also play originally produced Caribbean cultural and Afro-influenced music between our various news reports.